You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. Joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to check out his daily bankruptcy column, available on BloombergLaw.com and also on the Bloomberg Terminal. And we have a special guest today, Whalen from Tangent Capital Partners, joining us again. And today we're talking about fraud. It's been a theme that has run throughout our podcast whenever we've discussed, the big three bankruptcies of the last 2 years, or 4 years, Lehman Brothers, MF Global, and Madoff. You wrote a really interesting piece on your website talking about how fraud is almost becoming a defense. Could you explain what you mean by that?
Well, in the 1920s and the 1930s, fraud was an enormous problem. And in those days, oftentimes, if you had a corporate bankruptcy, the bankruptcy trustee was also appointed receiver. This allowed him to go after issues like fraud, whereas the trustee in a bankruptcy is really just concerned with the dead company, and they don't have an awful lot of power to do other things. For example, in the Madoff case, the trustee has repeatedly tried to go after third parties on behalf of the victims, but that's not his mandate. Mm-hmm. So you really have to understand that in the 20s and the 30s, fraud was front and center. But it actually took us about 10 years in that period to realize that fraud was the problem. So here in the U.S. today, we're going through the same thing. We've had several big failures where fraud was clearly an issue, but the political system, even the people in the market, still don't understand how to go at it, how to deal with it, and what mechanisms they have in place today to defend themselves from fraud.
And Bill, for historical perspective, why don't we have equity receivers anymore? I mean, it's like talking about the dinosaurs. I've never seen one appointed in my lifetime.
Well, that's exactly right. Neither have I in my career now, almost 40 years. Well, 100 years ago, most of the major railroads in this country were reorganized, not under bankruptcy law, because there was either no bankruptcy law at all, or there was no reorganization bankruptcy at the time. So they developed out of almost whole cloth this notion of a equity receivership. Mm-hmm. And all of America's railroads, in essence, were reorganized through equity receivership. Now, what happened after that was Congress used what was learned and law developed in the equity receivership to adopt the laws in the 1930s that really evolved into our modern reorganization law. Exactly. So what we're talking about now, and I think what Chris is alluding to, is that we need to go back to the notion of receivership to be able to let a trustee, in essence, in bankruptcy, sue for fraud, because right now what's known as the pari delicto defense stops a trustee like the Madoff trustee dead in his tracks, because the Madoff trustee is, in the eyes of the law, standing in the shoes of Bernie Madoff himself. So as a co-conspirator in fraud, old notions of equity preclude the trustee from suing anybody else in the fraud. Now, this is, of course, just absolutely backwards. Makes no sense, but this is the way the law is. And there's not much we can do about it without a change in law or, as Chris suggests, using receiverships instead.
Well, what's interesting is you could change the law, but even if lawyers today simply knew that there is one exception to the rule that says that you can go to a federal district court and ask for a receiver, and that's fraud. See, generally speaking, the equity courts don't want the bankruptcy courts to get into matters of property and life and limb. That's their province. They just want the bankruptcy court to deal with the immediate issue. But the trouble is, when you have fraud, you got to move quickly. You can't just let the parties run away with the assets. Stanford Group, when the federal district judge appointed a receiver, there was no bankruptcy, but everything stops, because the receiver has the power, since he works for the federal district judge, to freeze assets, issue subpoenas, get the prosecutors in there, whatever is required under his mandate from the court. So that's really the difference. If you look at Madoff, if you look at MF Global, the trustee is almost not able to deal with the issues that are so obvious. And that's why if you had a receiver, or if you simply appointed the trustee receiver as well and made him accountable to the district judge, then you could immediately go after these situations. You could claw back funds that might not otherwise be, you might not be able to reach out for. For example, in 2005, when Congress changed the bankruptcy code, they basically gave a safe harbor for the over-the-counter derivatives market, for secured lenders. So today in MF Global, JP Morgan can literally sit there with funds that could have been taken from customers, but because of the safe harbor, the bankruptcy court really can't go after them.
Well, Chris, let me ask you this. The equity receivership law is pretty vague to everybody these days, and what law there is, like I said, 80, 100 years old or more. why don't we just ask Congress to tweak existing bankruptcy laws, which are very well developed, and do something with this in pari delicto fraud defense?
That's right.
And also with a safe harbor. Why don't we just go to Congress and ask them to fix it? Wouldn't that do it?
I think you could. I think there's two things you would want to do. In a bankruptcy where someone makes an in pari delicto defense, the judge and the trustee should automatically be able to make application to the district judge and say, we need a receiver. And they can look at it. The district judge can then empower a receiver if it's appropriate. The other thing is that in many cases, I think it would be helpful if either the judge or the trustee or both had the power to review these things very early in the process, because once you've spent 6 months or a year in a bankruptcy, it's almost too late to go back and look. If you suspect there's fraud, people have to immediately raise that issue, because otherwise the opportunity goes away and the chance for equity, I think, is lost.
Well, you're a Congress watcher. Do you think this is an area where we can reasonably expect any action by Congress in the next 2 to 4 years?
I think it possibly, my friend Grover Norquist told me a while ago we needed 3 elections to get a new Congress in place so that they were angry enough and energized enough to look at some of these issues. I think, unfortunately, the Obama administration has let a lot of opportunities go by for prosecuting fraud in our industry. And had they done that, I think we would have better investor confidence. We'd have much better confidence from the public in our system. I think the biggest deficit we face today in our financial markets, Bill, is that people still don't trust the system. They don't see the law being enforced here in New York, for example, with mortgage-backed securities. There's all sorts of issues that are before the courts today, but the political system has still not gone after some of the bad actors, even in a political sense, and prosecuted them. You know, as a lawyer very well, there's 2 aspects to a prosecution. One is the political decision to go after them, and then the second one is legally, can you win? But I think there's an awful lot of people who were involved in fraud on the street in the last few years who deserve to be pursued, even if we might not win in court.
This is a big issue that has touched on some of the largest, most important, and difficult bankruptcy cases we've seen in the last couple of years. Chris, I want to thank you so much for coming in and talking to us about this.
My pleasure.
All right. That's Chris Whalen and, of course, Bill Rochelle. If you'd like to learn more about the cases and issue we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube and follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.